Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana.
And we are live. Very first day of the month of February 2025. Ladies and gentlemen, brothers and sisters, what can you do if your visa application is refused without a right of appeal? It's the community and the law brought to you by BWF Solicitors. And I want to invite you to come join me and my guest and resource person. We'll get into that next.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, welcome to February. Welcome to the community and the law, and welcome to the fold of BWF Solicitors. It's the very first day of February 2025, and we're glad to be with you this very Saturday afternoon to bring you the discussion that will help you, especially in your immigration matters. The question I'm asking this afternoon, and I know by courtesy of BWF Solicitors and also with the patience and knowledge that of our resource person, we're going to have the answer to the question. What can I do if my visa application is refused without a right of appeal? That's the question we're going to delve into. So I would want all of you to get ready and sit back, get your cup of tea on your left or right hand side, invite other people to subscribe to the channel BWTV, BWF Solicitors, and also stay with us throughout the discussion. My name is Oreku Frimpong. Thank you for being here. It's a new month, it's a new beginning, and definitely we're doing things so very right. BWF Solicitor says it's welcoming you to the very new month of February 2025, and they're saying that as we step into the new month, they remain committed to serving you with integrity, diligence, and excellence. Whether you seek legal guidance, protection, or advocacy, they are here to support you every step of the way. And with that, I want to welcome you once again to the community and the law. And let me first of all introduce my resource person, my friend and guest to the program this afternoon. It's no other person than our very own lawyer Charles Asma, who has the patience, the wherewithal, and the knowledge to share with us this afternoon. Uncle Charles, good afternoon.
Good afternoon, Brian Kuku, Patrick Pomoy.
Yami Adam Boko. I believe everybody in the family is also doing pretty well. And this
Everybody's good.
afternoon we'll have the opportunity of helping the community as well. And interestingly, every week I receive tons of messages from the community saying that they are satisfied with what you do, they are satisfied with what you give them, and also the knowledge you share with them. One very, very satisfied person is Ohima, who is saying that BWL Solicitors is the most genuine law firm I've ever come across in the United Kingdom. They do not take money for a case they know wouldn't be successful. I've been with them for more than 15 years. They did my family residence application, they did my sister's divorce, and my husband's divorce, all were successful. Mr. Osu and all his workers are the very best. I'm Charles. This is to put a feather in your cap. How do you react to this?
Yes, thank you to Ohima and the many others who always find the need to come back to tell the others that indeed they have tried, tested, and they are satisfied with BWF Solicitors. You see, law is with society.
Mhm.
Law is supposed to further our cause and advance our rights. And so if somebody is in trouble, the essence of the law is to see how the person can be supported. And what we do at BWF is to look at where the law sits with the person and to help the person out of that situation. And so what we seek to do is to make the individual or the person happy. Once the case comes, we analyze the case to see where the strengths are, where the merits lie. And we tell
Mhm.
them that these are your chances. You will then make a decision and work with you every step of the way within the rules and the laws to ensure that your chances are maximized for you. When the case is such that you don't have any chance at all, we'll let you know that there's no chance. You then make a decision as to what you wish to do. But the ones we touch, of course, we work with the individuals and make sure that we maximize the chances for them. And one such individual is Ohima. Every day we bring out what people say. And indeed, they all go to show that BWF Services is your community lawyers, and we aim to make sure that we don't just make you happy, we give you a testimony.
Just not make you happy, we'll give you a testimony and we're moving you in the right direction. So the other bit that BWF Solicit does is that they come into the community to educate and also empower people with knowledge so that sometimes they fend for themselves and understand what it is that is being done for them as well. So BWF Solicitors, we thank you so very much for all the wonderful things you're doing for the community. And I can see Ezekiel Johnson, Adai Taribo, Tilly Duma, Nana Jimain, and a host of other people who have joined us online. We're live on BWTV at Facebook, BWTV on YouTube, and all the other social media platforms. So once you join us, what you do, announce your presence as people have done, and then also advise that you like the page and subscribe to the notification so that when we put out content, you will be fed with it and you'll be notified as well. And then when you come on, please share and share and share so other people will join us as we have done today. Now, BWF Solicitors on the various platforms put out information beginning of every week, and then we come on the program every Saturday on the community and the law happens between 4 and 6 p.m. every Saturday, and we share with that. And of course, go to the further length of getting you to get the full explanation because the lawyers also take that up and explain to us. Now, this afternoon, what we put out earlier in the week is what I'm going to bring to you again, and you can find that on your screen at the moment. It's talking about sole responsibility when you bring your child to the UK. In an application to bring your child to the UK to live with you, where both parents of a child are alive and only one parent is resident in or moving to the UK, the immigration rules expect the relevant parent to demonstrate that they can have, or they can have, or they can solely take care of the child. I want to put it in a simple person's term, or they have sole responsibility for the child. So, what is that? Um, the rule says sole responsibility is not the same as legal custody or control. The Home Office caseworkers obviously will look at a child's circumstances as a whole to determine who is actually responsible for their upbringing, so controlling, setting, and providing the day to day direction and care for the child's welfare. Thus, I quoted from TD, that is paragraph 297 IE, known as sole responsibility. And it's from a case, Yemen 2006. Case number 0049 UKAIT. So, Lawyasma, I brought out all the legal terms and all the rest of it, but break it down for us. If we talk about sole responsibility, the caseworkers, what they are looking for, and to us, how do we understand this kind of definition?
Thank you very much, Brabuku. So, so simply means one. Shared means two people sharing a responsibility.
Yeah.
So, within the scheme of things and within the rules, if a child is applying through their parent to enter the UK with a view to settle, if it is visit, that's fine. But with a view to settle, they want to make sure that that parent is able to make the decision to bring the child to live with him or her in the UK. If it's a shared responsibility, then there's no problem. But it becomes a sole responsibility when one parent says that the other parent is not in the life of the child, and so I don't need the other person to decide where my child should live.
Right.
If you claim that there is sole responsibility, then your job is to prove, or he who asserts must prove.
Right.
So the law says that in bringing your child, and again, it's also about the protection of the child. Otherwise, people will be bringing other people's children to the UK or relocating other people's children. So we want to make sure that, one, it is in the interest of the child to be relocated in terms of the child's safety, well-being, and all other things. So the rules are set out such that under, for example, paragraph 297 of the immigration rules, if you look at subparagraph E, it will tell you that a parent who is seeking to bring a child to live with him or her in the UK must first prove that there is one other parent. If the other parent is not around or not part of the decision, then that parent must prove that they have sole responsibility for that child. Now, we look at, for example, the D part of the rule, which is 297D, ID. It will tell you that if the other parent is dead, then the other parent has the only responsibility left, sole responsibility automatically. So how do I prove that I have sole responsibility? One, I have to prove that the other parent is dead, and therefore I'm looking after the child alone. Now, in looking after the child alone, it's not just about the court telling you that you have sole custody, because sole custody doesn't make you a single parent. Sole custody means that you are looking after the child alone, but somebody else has a parental responsibility, and they can visit the child or make certain decisions pertaining to the child. Right. And therefore, the concept of sole responsibility, which means that the responsibility for the care, the responsibility for the upbringing, the responsibility for entirety of the child's life rests with one parent and no one else, has been tried and tested in court. So we look at the case of TD Yemen, and we say TD Yemen, it's a case, so TD is abbreviated name of the person for anonymity. The person's name is shortened, and the person came from Yemen, so we call it TD Yemen. Now, if the case was about a parent applying for a child under paragraph 297 of the rules, where sole responsibility became an issue, and the court concluded that to conclude or to determine whether the parent has sole responsibility, check whether this parent has control and direction for the upbringing and welfare of this child.
Okay.
So we then have to look at what is control and what is direction. And this control and direction should be full control and full direction, uninterrupted. So what do I mean? Simply, that parent is the one who makes all decisions pertaining to the life of this child, including the school the child attends, including whether the child name should be changed or not, including which hospital the child should be sent to, including even friendship and associations the child keeps, and any other thing that has to do with the life of this child.
Right.
So if you say in that you have sole responsibility, and therefore you don't need anybody else's permission to relocate your child, then the question is, how do you prove it? And
Right.
so today's nugget touches on something that caseworkers use to refuse applications that involve children. They will tell you that your mother or your father or the parent bringing you to the UK is not solely responsible because, one, the other parent signed a consent form. If you know that, that somebody signs a consent form, that person is giving permission, isn't it?
Yes.
Is permission a decision?
Well, it depends on the context, but yes, it's a decision. You are allowing the child to relocate, so it's a big
Very
decision.
good. Exactly. And therefore, if you have signed a consent form for this application for the child to be relocated, then you are in the life of the child, and therefore it can be construed that there is shared responsibility somewhere.
Mm-hmm.
So you'll be caught up on definition of sole responsibility. That means there's no full direction, full control pertaining to totality of the child's life, including where the child should live. And that's why you went to seek permission. So somebody signs a consent form, the other parent signs a consent form, then sole responsibility will be an issue. If somebody says that I have sole custody is not sole responsibility, because I can go to court and court will give me child arrangement order for the child to live with me. Custody means living with. So that my child can be living with me and not the other parent. But the other parent can have the right to visit the child. True or false?
Yes, true.
So if the other parent has right to visit the child and the child has, I have the sole custody, then there's no sole responsibility per se.
Mm-hmm.
It's just an arrangement as to where the child should live. So sole responsibility does not mean sole custody. And so today, if anybody is listening or watching, they have to bear in mind that merely getting a court order that this is Madam or Mr. A or B has sole custody for John Littleton, it doesn't mean that you have sole responsibility, because John Littleton's father or mother will also have this right within the scheme of things to ensure that John Littleton is happy and is always safe. And therefore, you have to always prove that there's nobody apart from you, the sponsor of this application, who has that exclusive control as to what happens to this child, and that you direct the life or the activities of this child. And so responsibility is not a tick box exercise. It's a whole box of things that need to be unpicked. And somebody will say, does it mean that it's up to the caseworker to say that there is or there is not? I will say it's up to the caseworker, but again, it's also up to you depending on the evidence you provide. Someone will say, how many pieces of evidence do I provide? I will say the more the better, because if you have a lot, then they corroborate each other to make your case meaningful or solid. So that is the conversation about sole responsibility as far as the nugget is concerned. Sole responsibility is not a legal custody, and therefore merely having a court order or court notice to say that you have legal custody or you are the person in charge of the life of the child is not the definition. And so responsibility cannot come from court in terms of document, but it should come from the totality of what happens to the child vis-a-vis you, the parent, and the evidence available.
So then we can conclude and take from Lawyer Asma's explanation that the decision about the child upbringing, control in setting and providing the day-to-day direction and care for the child's welfare would come into the definition of sole responsibility. Now, if you want to help provide such evidence and you are having any challenges, I would urge you to contact BWF Solicitors. They are on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340, 0208 493 7340, or the emergency line 077 127 61884. And if you want to get in touch with Lawyer Charles Asma directly and himself, please contact him on 07947 63 6037. 07947 63 6037. And also, if you have any questions or any concerns to express, especially whilst we live on this program, you can do that in the comment section below, either on Facebook and or YouTube, and we will pick that one up. Or you can send a text to our studio phone line 07399 208 468, 07399 208 468. You can send WhatsApp message to that line as well. And when we activate the lines, you can call us during the program on 0208 493 7345. It's the community and the law, and we have Lawyer Charles Asma as our resource person and guest. And this afternoon, we are discussing what to do if your application is refused and you do not have any right of appeal. What is that? We'll unpick that when we come back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we're back, and we want to say thank you very much for staying with us. It's a community and the law, and it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we are going to do a very interesting exercise where we will look at an application that you put in to the Home Office. Now, when you are putting that application, there are two things that can happen. I know I am right. If not, Lawyer Chasasma will correct me. Either the application is granted or refused. If it's granted, there are things you need to do just to make sure you get to sort yourself out and live in the UK for that period that your application or the visa that you applied or the stay that you applied for is given. When it is refused, there are other things that you may have to do, either do nothing or appeal. But there are situations where the Home Office says that for this application, you have no right of appeal. Oh, wow. So what do I do? Is it the end of the whole matter? What do you do? How do you go about it? This is exactly what we are going to unravel this afternoon. Your visa application when it's refused. Not just refused, but you are not given the right of appeal. Now, Asma, let me come to some basics. Why are applications refused?
Right. You're just asking a doctor, why do I get stomach upset after eating?
Maybe maybe your system cannot tolerate the food. It could be, or there's something in there that is not compatible with your tummy. It's about the same thing, or you didn't follow the rules of cooking, eating, and probably preparing the food. So then you've gotten it wrong, and your body is telling you so. That's what my
So
layman's definition would tell me.
I agree with you, Doc. Doc, you've passed you've passed your medicine 101. Yeah, so as you said, your body is telling you so that you did not meet the cooking and eating requirements.
Yeah.
In this case, it is not the body, it is the caseworker
Okay.
telling us so. In this case, it is not the cooking and eating project or test, but it is the visa application.
Okay.
In this case, it is not the body and the eating and cooking that are incompatible. It is the requirement of the application and how you went about meeting them.
Okay.
And so, if you did not meet the requirement of that particular visa application, the caseworker, which in your case was the body, will tell you that no, you don't qualify on this occasion to be granted a visa. Go back, revise your note, and get it right, and come again.
Now you've said it. So then, can I be of the assumption that when I don't do the application correctly, I can go back, correct it, and come back? Is that
Yes, you
correct?
can. Yes, we can. And there are some conditions. And therefore, on a balance of probabilities, other things being equal, yes, you can. Unless there are exceptional instances where you have to wait for a long period before coming back. And that is where you have gotten it wrong. So wrong by way of playing smart that you have been banned from immediate application up until 10 years within that part 9 of paragraph 9.7.2 of the immigration rules.
With the little legal experience you have given me, lawyer, I am assuming that when I put in an application and it is refused, I can come back to the caseworker and say, hold on, you have refused me based on X, Y, and Z, but I think you are wrong. Can I do that all the time?
So where there is need, the caseworker will tell you that you have been refused, but you have a right to appeal, or you have a right to seek administrative review.
Okay.
There are instances where the caseworker will tell you do not have right to appeal or administrative review. And so today our question is, what can I do if my visa application is refused without a right of appeal? Appeal means that you are not happy with a decision and you are challenging it. What if you don't have the right to challenge? The question is, should I be given the right to challenge? The answer is yes. So there are appealable decisions and unappealable decisions. An appealable decision will come with a right of appeal. Unappealable decision will come without a right of appeal. For example, student visas, you don't get a right of appeal, you get right of administrative review. Visit visas, you don't get right of appeal, you don't get right of administrative review. So you don't have anything. And that is exclusive, non-appealable, non-admin review decision. And so what do I do if you tell me that I am wrong and yet I can't do anything? Does it mean nothing means nothing?
Well, that's the obvious question I was going to ask. That if they say you don't have a right of appeal, does it end the whole thing? Or there are things that you could do probably to bring your attention to the fact that it could be a genuine mistake or a genuine mistake, let me put it that way, either on their part or on the applicant's part. What can I do?
Yeah, thank you very much. Yeah, so these conversations bother on public law or constitutionality. So that's an area of law that deals with behaviors of public bodies. The decision maker is a servant of the public because they work for the Secretary of State, which is an agency or a ministry. So if the Secretary of State, which is a public servant, acting through the caseworker, either abroad or in country, says that you don't deserve to be given a visa, and at the same time, you do not have the right to appeal, we have to look at whether what they are saying is legal, what they are saying is rational, and what they are saying is fair.
Legal, rational.
Legality, rationality, and fairness.
Okay.
Call it FLR. Fairness, legality, and rationality.
Okay.
So if the decision is not fair, then it borders on constitutionality. A public body making unfair decision.
Okay.
It's a breach of constitutionality or constitutional law, public law.
Okay.
Or a public body making an irrational decision that is not rational. It doesn't make sense in the eyes of the ordinary person, what we call the Wensbury reasonableness test. A Wensbury reasonableness test is a test that whatever is happening or whatever is being done, will an ordinary person with a full knowledge of the story conclude the same way? That's a simple explanation, but there's case law to it. And so if an ordinary person, objective bystander, concludes that this decision is not rational, it doesn't make sense, then it's a public law matter.
Okay.
Or whether the decision is legal in the sense that it followed through procedures properly and it breached any law. If it breached any law, then we say that it is illegal to make that decision. For example, you say that I have done something wrong and yet you don't give me right to respond by way of minded to refuse or minded to ban notice under the what we call evidential flexibility principles or rules, then your decision is no legal in sense. So if one of these 3 points are engaged by the decision maker, then you can say that the decision that is given to you is faulty in one of these 3 areas, and so you can move to the next stage. If you had a choice, you go to the normal stage. but you are not given a choice. And so you have to go to the stage that allows you to explore your public law rights, and that is judicial review.
Now, if you say judicial review, who I know you'll be taking us through the steps, but let me jump in and say, who does the review? Is it me and my lawyer, or I'll have to definitely go to court?
Right. Judicial review, as the word suggests, is court review.
Okay.
So if court review, then you go to a court that has jurisdiction or power to look at that matter. So in this case, you will not go to lower court, what we call immigration tribunals. You go to upper court, what we call upper tribunal. So
Okay.
the upper tribunal that deals with immigration matters will be looking at your case, what we call a claim that you are making, that the decision made by the public officer is illegal or irrational or unreasonable or unfair. If one of these points are raised, then that will be your basis for seeking the court's review. Because you have not been given the power to appeal, you have not been given the power for themselves to review, what we call administrative review.
Okay. So I have put in an application. In my mind, everything was okay. But it goes to the caseworker, and the caseworker says, no, I can't grant you this because you did not meet the requirements, because you did something wrongly, because you misrepresented some situations. You do not have the right of appeal. What steps can an individual like me in this situation take? Lawyer.
Thank you very much, Brakoku. So, viewers and listeners, today we are saying that if you cannot go to court for appeal or you cannot go to Home Office for administrative review, then you can go to upper level court for judicial review, for the court to review the decision to see whether it breaches any of your rights under public law. I'll ask producer humbly to share the note, a note for us to have a context. So this is a guide on judicial review, and I'm going to be brief on this. And we acknowledge the source of this information. We took it from the Public Law Project. And so if anybody wants to access the information, they can go to that to get it. But we are grateful for the source and to the source. So a brief guide to judicial review procedure. What is judicial review? I have already explained judicial review, so I'm not going to burden viewers and listeners with that. But the main thing for us is that you have been given unlawful decision and that you do not have any other option open to you to seek remedy. If you have an option open to you for remedy, then you cannot go for judicial review. That's why this is good for somebody who do not have appeal right or administrative review right. If you have administrative review right, you cannot go for judicial review because you have alternative remedy. If you have appeal right, you cannot go for judicial review because you have alternative remedy. And again, it has to be a decision by a public body. Today's conversation is about immigration activities. So we are limiting ourselves to immigration area. Now, what makes a decision unlawful? We've touched on that: illegality, irrationality, and unfairness. Now, if you go down, we are looking at, stay there for, no, just up, that bit, yes. So, Brakoku, take us through the bit. Be fast about that. Illegality, refusing to act, and also taking irrelevant factors into account. Just the illegality bit for us, please.
Public bodies must correctly understand and apply the law that regulates their decision-making powers. An action or decision may be unlawful if the decision maker had no power to make it or exceeded the powers given to him or her. Four kinds of illegal activities may be identified. We're looking at refusing to act in a certain way in a mistaken belief that the Lord does not allow the body to act in that way. The other bit is misuse of discretion. For example, using a discretionary power for the wrong purpose or in the wrong circumstances, or putting unlawful limits on the exercise of discretion, often called fettering of discretion, and typically applying a local policy rigidly. The third one is taking irrelevant factors into account or failing to take account of all relevant factors. And lastly, failing to take account of the Human Rights Act of 1998. This short guide cannot deal with the details of the 1998 Act. You can find that information, that and all.
All right, of course. So failing to take account of human rights of the applicant. Again, taking irrelevant factors into account. You know that most of the decisions that caseworkers often take tend to appear that they have taken a lot of irrelevant factors into account and concluded that, no, we are refusing you. It doesn't make sense to tell me that, yes, my financial circumstances, to tell me that, what if you go, you will come, to tell me that some of the excuses are flimsy. And this could be irrelevant factors, what we call perverse factors. We're also looking at misuse of discretion. Yes, you have discretion to refuse, especially if you think that the person hasn't met the rules. But you also have the power to ask, you also have the duty to ask for clarification or explanation before you conclude. And so if you fail to do that you fail to act and you conclude that the person must be refused and you refuse the person, that's like misusing your discretionary powers. That is also no good. It's also under illegality. We are saying that you have refused to ask for further evidence under evidential flexibility, or you have misused your power to refuse a visa application because you think that it is up to you to make a decision and you have made that decision wrongfully. Again, you have taken irrelevant factors into account and you have concluded that I do not meet the rules. If you had gone a step further to make a holistic assessment of the evidence, maybe the outcome would have been different. And also failing to take my human right into account. And so when something happens like this, then we see that there's wrongdoing. The person can take action. Now, once we have, I think with this conversation and as the clarification we have given, viewers have an understanding of, okay, and that is why I can go to court for judicial review. And therefore, we are not even going to go into the irrationality and unfairness. But suffice to say that if illegality is giving us about 4 points, irrationality can give us further more points, and unfairness can give extra points. And so you can have about 10 reasons why you can go to court for judicial review when your visa application has been refused. Now we are going to go through the process.
Okay.
So once you have been refused, example, visitor's visa, because that is where people do not have appeal right or administrative review rights. So there's no other alternative remedy, and the only thing open to you is to go to court on the basis that the decision is irrational, the decision is illegal, or the decision is unfair. Once you have established the issue and you have set out the reason why you are going to court, you make an application, and the application will go to upper tribunal. Tribunal, they have the locus to look into that matter, or they have the power to look into that matter. If you take it anywhere, you are wrong. And again, it has to go to that particular court. So if it is immigration, it has to go to upper tribunal that deals with immigration matters. If it is tax, it has to go to the tax court. Whatever it is, it has to go to the appropriate court. Because ours is immigration, it will go to the one that has power to deal with immigration and asylum matters. You make the application online. It used to be paper, but it is now online. We call it e-filing with all the necessary tick box exercises. You complete a form, and the form is called UTIAC. UTIAC means Upper Tribunal Immigration and Asylum Chamber, ITIAC. There are a lot of forms. So you go for ITIAC 1, which is the form to apply to court for judicial review. The fee is £169, and you have to complete it and give reasons why you think your matter or your claim should be heard. We call it grounds. If you don't have good grounds, the court will not entertain your application for a review. You have to add a decision to it, add your evidence, and add your reasons or the grounds, the legal argument, put them together and send it to court. Depending on where you are making the application from, you have a certain number of days. If you are doing it from within the UK, you have 14 days. If you are doing it from outside the UK, you have 28 days. Whatever it is, you have to make sure that you have responded in time. However, because this is judicial review process, you still have liberty within the scope of judicial review. And so the time is extended to 90 days. 90 days. Within the 90 days, we are counting from the date the decision was made. The date the decision was made. So if the date the decision was made is when you received your application for the refusal, that is the 90 days. However, you cannot go to the court to seek review if you have not first dealt with this through the individual concerned. The individual concerned will be the caseworker or the Home Office. So you go to the Home Office or the caseworker to say that I want to challenge your decision at judicial review, and so I'm putting you on notice, what we call claim or notice before claim. And that notice before claim, we simply call pre-action protocol. You send your reasons to them and you tell them that you want them to look into the matter. If they don't look into it, you take action. So they have time to look into it. But they can come before or they can come later. So you have to count your 90 days from the date the refusal came. If they come with your response to your notice that you want to take action against them after 90 days, then you don't have to wait for 90 days to be up. So within that 90 days, whether they've come back or not, you can go to court. Again, if they come back to you within the 90 days and they say that we have concluded that the decision is still good and you can do whatever you want to do, then that becomes the final decision. So your 90 days can also count from there, what we call the relevant date of the relevant decision. So it depends on the circumstance and it depends on the action you have taken and the response that have arisen from that action or those actions. Once you apply, you pay your fee, you wait for the court to respond. Now, when you make an application, you are telling the court to do something. You are either telling the court to make an order of injunction, to tell them that, for example, they are sending you away. But today we are talking about refusal. If we are talking about refusal, then there's no pressure or urgency, and therefore injunction is not necessary. But if somebody is being sent away because their visa has been cancelled and they are being deported, then you can seek injunction as part of the remedy you are seeking. So injunction will hold the action they want to take. So if injunction is not necessary, you don't have to ask for it. The next one is what we call mandatory order for them to do the right thing, i.e. to give you the visa that you have asked for. And that mandatory order will mean that you want them to consider the decision and make the right decision. And if you feel that you are 100% sure that the visa should be granted, your request is for the court to conclude that the decision should be reversed and grant you your visa that you seek, or the entry, clearance, or leave to remain. Once you make the application to court, okay, let me pause here. You may have something.
Yeah, what I was going to say is that when you make the application to court, And in the meantime, what happens to you? For instance, if you made an application to probably extend your stay one way or the other, or you are being minded to leave the country and the rest of it. If the injunction is put on, does it mean that you would have to stay put? If you're working, you can still work until the final decision is made. Is that what it is?
It depends on what you had before the decision.
Okay.
If you had right to do A before the decision was made, then insofar as the action is not over or the process is not over, such right will continue. But if you don't have any rights, then you don't have anything in the meantime whilst you are waiting for the court decision. So it depends. If somebody had a visa, they applied before the visa expired and they were protected under Section 3C of the Immigration Act of 1971, and the visa is refused. There's no right of appeal or whatever, depending on the circumstance, or their visa has been cancelled and they've been asked to go and they don't have any right. Then once they put in the judicial review, it will, because the judicial review is for the court to review, and in the meantime, they have to allow them to exercise whatever right they had. So it all depends on the context and what the person had before. But suffice to say that at this point, the individual is seeking to reverse the decision as opposed to even asserting their existing right. And so the court will look into that and make their own decision. But because it's a very technical and law-driven exercise, you have to make sure that you tick the boxes and go through the process step by step. Because if you slip, the whole exercise shuts and you can't continue. How do you slip? For example, you are supposed to pay a fee of £169. You didn't pay. Then that will go against you. Because the court will not even entertain your application. And by the time you realize, the time is also up. Or you don't complete the form properly, you don't add the grounds and do whatever you need to do, then the court will not approve or accept the application. So the application can be rejected if it's not properly done. Again, if you make the application, the court will come back to you to accept or reject. Once the court accepts, the court will stamp it to say that it's been accepted. We call it a seal. So once the seal is placed, we say that this is a sealed JR, judicial review. In this case, the other party must be notified. So you fill another form called UTAC 2 or notice to the other side service to let them know that the court has approved this. You take it to the other person. But of course, you let the court also know that you have served. So once the court seals it, you tell the other person, which is the Home Office, that the court has sealed it, and therefore my application has been accepted. Then you go back to the court to tell them that I have notified the other person, which is the Home Office, that the process is now complete. If you don't do that, thinking that the court has accepted and that's it, after a certain period, you are late because you didn't notify the other party. And the court will say, because you didn't notify the other party, you have not followed the rules. And so the application is no longer continuing. So there are a lot of processes to follow. But because we are not talking about the processes per se, we are just talking about the fact that if you are refused without appeal or judicial review right, you can go to court. You have the right to do it yourself or you seek the support of a lawyer. If you are doing it yourself, you have to make sure that you tick all the boxes. If a lawyer is doing it for you, the lawyer will take instructions from you and follow the process through for you.
Well, the situation is not a dire one. If you think that the decision made is wrong and you have a strong feeling that you can appeal to that, you either do it yourself and do the process right and follow all the processes and or seek legal advice. What I would advise is that you speak to BWF solicitors on the number 0208-493-7340, the emergency being 077-127-61884, or you can call lawyer Charles Asma directly on 07947 636037. What we've been discussing is what you can do if your visa application is refused without a right of appeal. Lawyer has given us the criteria and the broad things that it should come under. It should be rational, it should be legal, and of course, it should consider your human rights as well. And all these things, if you have any questions, you can speak to BWF solicitors, as I said, or right on this program, you can put your question and your comments right down in the comment section below, or you can text us on 07399 208 468 or call 0208 493 7345. It's the Community and the Law is brought to you by BWF Solicitors. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, you're welcome back, and thank you for sticking around. It's the Community and the Law, and it's brought to you by BWF Solicitors. As I mentioned earlier on, if you have any questions concerning our topic for discussion this afternoon, which is what you can do if your visa application is refused without a right of appeal. Lawyer Charles Asma, a resource person and a lawyer from BWF Solicitors, is giving us the steps and the process to go through that. We will take a few questions, or I'll pose a few questions, then we'll come to pick up your comments and your questions from the comment section and from our text. And if you were to ask your question yourself, you can call in on 0208 493 7345, 0208 493 7345. Now, Asma, let me look at this. If I to appeal or to go for a judicial review because I know that there's been a mistake somewhere, the decision is not fair to me, it bothers on my human rights, it's not rational. They have brought in all those issues that really should be on the periphery and irrelevant to the case. How much do I have to pay the court, one? And how long does it really take for a decision to be made? Is it a case that can drag on for days, months, or even years?
Thank you very much. You see, judicial review. So we are giving the matter to grandpapa to look into
Mhm.
it. Grandpapa will need time. We need clarity of eye and ear to make sure that everything is right to him to be able to make a decision on that.
Mhm.
Grandpapa will also want to give everybody opportunity to speak and to bring their evidence.
Right.
Now, at the outset, the application will be considered without hearing. So you don't have to be there. And
Okay.
so make sure that your evidence is solid. If it borders on human rights, put in your human rights consideration as well. Put in everything at this stage. Don't say, I'll wait. This is your chance. So you put in at the initial stage. Once the matter goes for review, the judge will consider yes or no to
Mhm.
grant. So this is application to seek judicial review. And once the application is granted, you will then be given opportunity to move to the next stage.
Okay.
Sometimes the application will not be accepted on paper. Then they will ask you if you want to challenge it orally. You want to challenge it orally.
Yeah.
In this case, if you are challenging it orally, you tell the court that, yes, you have made a decision, but I'm not happy. Not that I'm not happy because I'm sentimental. I'm not happy because I don't think you have done due diligence with the review because you didn't hear me out. And so I want to be heard out. So then you apply for oral hearing. That is step, you see, the next phase. So that you will be there, Home Office will be there to contest it face to face. Then court will make a decision whether to accept or not. Once the court accepts, yeah, if the court doesn't accept, you go to the next stage, Court of Appeal. Then you make an application for judicial review for the Court of Appeal to hear the matter, so more or less to give you permission to seek review of the matter. So sometimes you hear that a matter has traveled to Supreme Court. I'm sure you've heard about that before. For example, remember the old case of is it Abu Qatada or something? You remember the man who was going to be deported, the Muslim preacher, and they said that he was fighting his way. He fought up to Supreme Court level. There are a lot of cases that has seen judicial review up to Supreme Court level. So if he has to go to Supreme Court, it will travel up to Supreme Court. And so if he's going to go up to Supreme Court, you can see that it's going to involve time and patience. But if it's at the peripheral, like simple refusal of entry clearance, that may end maybe at the Court of Appeal, depending. But again, if the Court of Appeal says no and you are not happy, you have a right to go to the next level. But the longer it travels, the more expensive it gets. The beauty of it is that whoever wins will have the other party pay their cost back to them. And so, how do you gauge your winning power? Because it's possible that you spend about £20,000 fighting judicial review and you win. If you win, Home Office must give you your 20,000 back. If you lose, you have to pay your own 20,000 and pay Home Offices, I don't know how much they would have spent. And so, in terms of winning, you get your money back. By losing, you have to pay the other side. So that is something for us to consider. And so, whilst we are considering the right, we're also considering obligation in terms of cost under this process. It's also possible.
I think the ordinary person's question at this point will be: is it worth it?
You see, if you are very confident about your claim, then it is worth pursuing, especially where there's no other remedy available. And especially where you believe that one of the three cardinal principles have been engaged: legality, rationality, and fairness. And if it's a case of fairness, especially human rights, then it's worth pursuing.
Okay. Well, your comments are welcome now. Your calls are welcome now if you want to. Your text messages are welcome now if you want to. 0208-493-7345. Or you can send a text and WhatsApp message to 073-99208-468. Lawyer Charles Asma is here. Even though we've discussed what you need to do or you can do when your visa application is refused without the right of appeal, but other questions are also very much welcome on the platform and on the program. Remember, it's brought to you by BWF Solicitors. Edubuahin says, I came to the UK through my EU partner. I've not done the full 5 years before I applied for indefinite leave. Can I divorce my husband now? If it will be possible to get my indefinite leave when the time comes. Like,
Okay, so let's drill down on Edubuahin's claim. You came through your partner.
mhm.
You have not done 5 years. And you have, before I apply for I have not done the full 5 years before I applied. Is the word applied or apply? You think it's
I think what
applied?
what he wants to mean is not they've done the 5 years and thinking that after the 5 years they can apply for
Oh, I have
indefinite.
not done 5 years before I apply. Okay. Can I divorce my now it is possible? Okay, all right. So what our brother is saying is that I came as a spouse of an EU national. The
Mhm.
marriage is broken down irretrievably. I have not gained my indefinite leave to remain, but I'm no longer going to be with my wife. What do I do? What does the law say, right? Yes. Can I divorce my husband? I mean, you won't say, nobody will advise you divorce your husband if there's no reason. And therefore, what you are telling us is that your marriage is broken down. Can you divorce? If the marriage is broken down, yes, you can divorce and will possibly get my indefinite. So it's not because of the indefinite. That's why you are divorcing. You are divorcing because the marriage is broken down and there's no chance of reviving it. The law says that if the marriage is broken down irretrievably, you can divorce. So there's divorce. Your question is, what happens to me if there is divorce? If there is divorce, because this is under EU provisions, the law says that once there is divorce, there's what we call supervening event. And you have to show with your supervening event evidence, which is the divorce certificate. The law says that because of this, your right will continue. But for the divorce, your husband would have sponsored you up to indefinite. So if there is divorce, that does not take your right away. And therefore, once you have done 5 years, you can apply for indefinite under your retention of right processes, what we call retention of right. So retention of right, you have to still wait till you are 5 years before you go on to indefinite. You don't divorce today and you say that I'm divorced and I hear I can do the retention of right, so I'm going to do it once I'm 4 years. No, your application will be invalid because you haven't done 5 years under that route. So you have to wait. But once you are ready to apply for indefinite, will you be refused because your husband is not going to show evidence that they live with you? No, this is different from other types of applications. With this type of application, the law says that your right under EU will remain as before. You just have to prove that you are with the person up to the point of divorce. And since then, you are not with the person anymore. And the divorce certificate will replace the sponsorship. You can apply for indefinite.
Yes, keep them coming through. 0208-493-7345 or 073-99208-468. Citizen Kwejo says, if an application is rejected after a 14-day period was given to provide a valid certificate of sponsorship under the care route, and the applicant is advised to submit a new application soon if they have any reason to remain in the UK, what is the time frame for doing so since it was not specified in the email? Additionally, since the applicant's and dependent's documents expired about 2 weeks ago, are they still covered under Section 3C protection? Can the applicant's partner, who was part of the rejected application, was previously the main applicant on the expired visa, submit a new application if they obtained a new COS that covers both of them. So it's like, yes, you had it now. Now I have it. Can we reverse the rules and cover each other? And the time frame for them to be doing any application. I think this is about what Kojo is talking about, lawyer.
Yeah, okay, thank you very much, Kojo. So we'll leave this question on the screen. So, Brakoku, we're going to take the questions in turns. The first one is that I'm refused skilled worker application. I'm asked to make an application if I have another reason to remain. How long should I do that? Should I put in that application? Whenever you are ready and you meet the rules, it's up to you. I'm just telling you that you don't have a visa. So if you have anything to do, you can do it.
But this one is saying that after a 14-day period was given to provide a valid certificate of sponsorship. So does it not mean that, I think that's probably where Kojo's confusion may be, that
Well,
there's a 14-day period in there. Is that a caveat?
well, the 14-day period is the evidential flexibility time frame. So you've been given 14 days to provide the evidence you are relying on for this application.
Okay.
Now, I want to believe that the 14 days is elapsed, or the 14 days hasn't, but the person has been told that you have 14 days to bring the evidence, or you can make another application. If after 14 days
Another one.
you do not send the evidence, they have to refuse the application. But in this case, I think it was about rejection, wasn't it? Was it rejection? Rejected, yes.
Yeah, it says applicant
Rejection.
rejected, yeah.
So once the application is rejected, that means it's not valid. So they have to prove that it is valid. If they give you 14 days, if you don't respond, then it is totally collapsed. Then application is no longer going on.
Okay.
And at that point, you are as bad as not having nothing, because your visa potentially had expired within that period you were applying. If the visa had not expired yet, then that's fine. You can put in another application within the validity period of the existing visa. But once the existing visa has expired, you have no leave. But you can still apply under human rights as a parent, as a spouse, or under your private life if you qualify or you meet the requirements for each of them. How long is up to you, how soon you want it.
Okay. The other part of the question says, additionally, since the applicant's independence document expired 14 days ago, are they still covered under Section 3C protection?
If the documents have expired 2 weeks ago, that means it's expired. They can apply within the 14 days under paragraph 39E, which says that you have a grace period to make an application, to renew or to switch. However, because the visa is already expired, you are no longer protected under Section 3C.
Okay.
Yeah.
So if it has expired, you are not protected.
If it's expired, you are not protected. If it hasn't expired, you are protected.
You are protected. Okay. Then the last bit of the question says, can the applicant's partner, who was part of the rejected application and was previously the main applicant on the expired visa, submit a new application if they have obtained a certificate of sponsorship that covers both of them? So now it looks like a dependent is becoming a main applicant, and the main applicant is becoming a dependent because the previous one was rejected. Is that possible?
Yeah, well, the point here is it depends on the context, because we are still looking at whether the other partner who is seeking to apply under skilled worker route had or has leave to be able to move to an application. So
Okay.
if, for example, the person is still a dependent and the visa is still valid, then if they find an employer themselves, they move on to become the main, and they go with their partner, who was then before them, then the main. But in this case, we are told that 14 days has elapsed, the application is rejected, then I'm sure the visa has also expired.
Right.
If it is expired, then they cannot move to another employer visa. or they cannot obtain sponsorship and apply, because with sponsorship applications, you are transferring or switching what you have for another.
Okay.
So
All
if
right.
at this stage your visa has expired and you find another employer, then your best bet is to go back to your country and apply to enter again, because you don't have the leave to move on from.
Okay. Well, keep them coming through, your comments and your questions in the comment section on the text, or you phone in and do. The next year comes up with this one. Human rights application is refused. The applicant is destitute. Sorry. Applicant used fee waiver. Applicant cannot afford a lawyer or barrister fee as well as court's fee. Is there a fee waiver if applicant can pay the court fee? If applicant can't afford the lawyer and barrister's fee, can they go alone even though they may be ignorant of the law? Well, I dare say that when you're going to court, you're not strictly obliged to take a lawyer if you can speak for yourself. There are venues where you can look for legal aid, but ideally, you may have to go for legal support to put up some of the arguments for you, especially preparing the bundle and the rest of it. Lawyer, would that be enough?
Right. So when it comes to immigration applications, we talk about fee waiver if it borders on human rights. When it comes to court challenge or litigation, even if it is human rights, if you can't afford, you go for legal aid, no fee waiver, because it is not a fee that is restricting you in any way. It is just the cost, the litigation fee. A litigation fee should not be compulsory on you. If you want it, you go for it. If you don't want it, you do it yourself. You just pay the court fee, not the lawyer fee. So, Nana, what I would say is that there's no fee waiver in litigation, but there's legal aid in litigation. So speak to legal aid lawyers, and they'll be able to assist our friend who is making human rights claim in court.
Yes, I want to remind you that we had the nugget earlier on and was talking about sole responsibility. I'll be testing your knowledge on that. We talked about the Home Office caseworkers who will look at the child's circumstance as a whole and then determine who is actually responsible for the upbringing. Sole control is looked at. Sole control is looked at in the context of setting and providing the day-to-day direction and care for the child's welfare. So think through that. I'll be bringing you the question, but let's go on to pick up some of the comments and the questions we still have on there. So Asma will help us do that. Charles says, I want to know if the Minister of Religion sponsorship is still available. Asma.
Right. In terms of Minister of Religion sponsorship, depends on, there isn't indication, I might not have heard it, but as far as I'm aware, there isn't indication that that provision is cancelled. It depends on whether you have sponsorship through that ministry or that religious sect. So I think your question is, can I still go ahead and look for one? Yes, you can go ahead and look for one. If you want, I may have to check to see whether it's been cancelled at this stage, but I'm not aware. You can call later to remind me to check to see whether the scheme exists. But in terms of if it exists, whether you can go on to it, yes, it's there for you to.
Okay, so if you really want to get in touch with lawyer Charles Asma directly, you can call him on 0794 7636037 or call the BWF Solicitors Direct Line 0208 493 7340 0208 493 7340. Let's get on some of the questions as well. Toyasi Adeniji. I have an application before my current document expired on the 24th of January this year, the 2024 last year. Can I put in another application while still waiting for the other application that has not been decided on? Two applications can that happen concurrently?
Right. So the person will not be making a concurrent application, but will be varying the existing application. The rules allow for variation of application if decision is not yet made. So once you are applying again, they will ask you, do you have a pending application? You say yes. They will ask you for the pending application's reference number. You put it in and you continue. The presumption is that this new one is taking over the existing one.
Toyo, that's the answer to your question. Keep them coming through. Keep them in the comment section. We're live on BWTV on Facebook and YouTube, and BWF Solicitors Facebook and YouTube as well. How do you check if sponsor licenses is activated?
Right. You go online and type sponsorship license register, or you can look for licensed employers list. Any keyword you put into the search engine, it will come up with the full list on a spreadsheet. Then you can search the particular employer that you are doubting.
Okay, so yes, we're still having more to go. Christiana says if an application is rejected, then the applicant is advised to submit a new application as soon as to remain in the UK. What is the time frame for doing so? Additionally, since the applicant and dependent documents expired 2 weeks ago, as they still got, I think Nana brought in the second part, but if the application is rejected and is advised to submit a new application, time frame, lawyer, I think maybe for purposes of emphasis, you may want to answer this again.
So if the application is rejected, sometimes they will give you time frame. They themselves will give you 14 days to make a new application. So it depends on what they said. If they just rejected the application and they tell you that go home or make a new one, then what they are telling you that you don't have anything. So if you want to make a new one, it's up to you. Then you are starting from ground zero. But if they say that your application is invalid, we're giving you 14 days to make a new one. If you're thinking of remaining in the UK, then you know that they have said that you have 14 days to do something.
Something, don't sit idle. I would ideally advise you to speak to lawyers who will help you, speak to BWF solicitors. They will gladly help you.
And I think the third part, Brakoku, the third part to this question, I think it wasn't part of the first one that came. Would submitting a fee waiver application be a better option? Which one is that? Additionally, please read the additionally bit.
It says, since the applicant's dependent documents expired 2 weeks earlier, I think that's what she wants to, are they still covered under Section 3C protection? And then continues to say that would submitting a fee waiver application be a better option?
Well, okay, if the visa is expired, I think it's the same as the one that came before.
Yeah, that's why I said for purposes of emphasis, just answer the question. Yeah.
So if the visa is expired, you are not protected under 3C. If you are making a human rights application, i.e. partner, parent, child, or private life, you can always apply for a fee waiver if you meet the fee waiver rules or requirements. In other words, if you can't afford the fee, or if by affording the fee, your child will be in trouble or will be at risk of not getting the best care from you financially, then you can. Or even if you are going to be imminently destitute after paying the fee, you can all use these reasons to seek fee waiver. So yes, fee waiver if it's a human rights application.
Okay. If it's a human rights application, I think that emphasis should be made again and again. Remember, if you have been following this program, there was a point that we said the Home Office would probably punish people the more, and they look at that as misrepresentation. When you are applying for fee waiver, if not under the human right protection. So if you're in doubt, ask and ask BWF solicitors, they'll help you. Yes, let's see if we can pick up further questions. Jake Carmo is asking whether we can go for fee waiver for child registration.
Child registration, of course you can. Yes, you can. Yes.
I can feel from the emphasis on the yes that Jacamo will be very excited about this situation. Jacamo, yes, get in touch and let's start your process for you because you can. 0208-493-7340. Put your comments in the section below, down on Facebook and YouTube, BWF Solicitors, BWTV. Nanasewa Kusiabunsu says, my child had a cataract surgery and that eye has been replaced by contact lenses. Can my child come in with a visit visa and then switch to a parent route whilst in the UK? Laura.
Is the child coming because they have said, is my child had cataract surgery in the UK or where? They didn't say.
So
I
assume that they did the surgery outside of the UK because the follow-up question says, can my child come in with a visit visa and switch to parent route while in the UK? So I'm assuming that when they come in because of their medical situation, they want to stay on with the mother or the parent and then probably have further support and help.
So within the rules say that if you're a child in the UK and you have a parent who is British citizen or has indefinite leave to remain, or even 2.5, or pre-settled or settled, you can apply on human rights grounds to remain with your parent because it will be better for you to remain with the parent than going back to the country where maybe only other family members are looking after you. And so you can put in the application either within the rules or outside the rules. You can put in application to remain with your parent. But the person is not visiting the UK because they want to enter and do that. They have entered naturally to visit their parent. They have entered naturally for medication. They have entered naturally, but for good reason. They are considering to remain with their parent. The question is, can that happen? Within the rules, yes.
Within the rules, yes. If you have any further questions, talk to BWF solicitors, or you can talk to lawyer Charles Asma as well. We're still picking up your comments. We're still doing the responses to the questions and the comments you bring. Is it possible that a company that is on the sponsor license employer list after the documents as there has been a case that the said sponsor is on the license employer list and the application was rejected on the basis that the application is fake? How else can we know? I think the lawyer may make some meaning out of your question, Toy. Laura, let's see.
Yeah, I agree with you that how will an innocent member of the public making application believing that the advertisement made by the employer hiring people and everything were genuine, you going through the process to apply, if the COS is fake, it is a fake document, and that falls under Part 9. Either you'll be refused or you'll be banned, one of them, or both, of course. I'm not sure what happened, but I suppose in your case, you were refused. If you were refused, praise God, because at least you haven't been fully restricted for 10 years. What it means is, if you still feel that, how could I have known? And why should this be my fault? And why should you punish me for somebody else's trouble? Then you can seek judicial review for that unfair decision, which is the topic for today. .
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, you're welcome back. We're still live on BWTV, and the program is the Community and Law. I mentioned that you can call us and ask your question directly to Lawyer Charles Asma. So we go to the lines now, 0208 493 7345. And I have somebody on the line already. Hello. Hello. Hello, my dear friend, can you hear me? Oh,
Hello. Okay.
yes,
Thank you,
yes, yes.
Mr. Charles, and then our brother on the program. My question is, if let's say I've retained my rights as an European, and then I have my settlement. If in case now I have kids back home, and then I want to go and marry. I've met someone I want to marry now. If I'm after marrying the person and I want to bring the person and my kids from my previous marriage, I want to find out, do I have to pay for the NHS and the immigration health surcharge?
Yes, lawyer. If we can help our brother.
Our brother, how are you?
Fine, thank you, Lawyer Charles.
Good. Are you applying for your family members under EU?
Yes, please.
Are you a EU national?
Yes, please. Yes, please. I retain my through retention
No,
of rights, and then after
no, that's not the question. Are you a EU national? You.
No.
So you can't apply. They can't come under EU. They'll come under the normal immigration rule. They pay the fees.
For both, for my kids as well.
Everybody who is applying.
Sorry.
How many people are applying?
The two kids, which I had some years ago before I even came to the UK.
I understand. How many people? So your wife and the children, right?
Yes, and two kids. Yeah, two children. Yeah.
They all pay the fees.
Oh, okay. Oh, okay. Because the reason why I'm asking this question, let me explain so that maybe other people could understand. I was thinking if I apply for my British passport, I have to pay. But if I'm still holding the settlement, which is the EU, I don't have to pay. So if you have explained to me that I'm not an EU national, and for that matter, I have to pay for all of them, I think that's okay with me with the explanation.
The thing is, you have told us that you have divorced your wife, right?
Yeah, exactly. Yeah.
So is your wife the one bringing the stepchildren? And
Yeah.
what was the okra or then you bro?
Your rival.
Is she bringing the rival and the stepchildren? No,
Okay.
exactly. So now it's
Okay.
you are bringing them, and you are foreigner with settled status. So you operate under immigration rules, not EU rules.
Okay. 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 All right. Thank you very much, Lawyer Charles. Thank you very much.
And thank you to my brother for having trust and faith in BWF solicitors, bringing your question here. And definitely, if you need any further assistance, as we keep saying, 0208 493 7340. Well, at this time, I think we will quickly look at our nugget again. I mentioned earlier on that I was going to bring that back, one, and also to ask you a question to test your knowledge and understanding of the situation. We talked about what sole responsibility was when bringing your child to the UK. And what we said was that in an application to bring your child to the UK, specifically to live with you where both parents of a child are alive and only one parent is resident in the UK or moving to the UK, the rules expect the relevant parent to demonstrate that they have sole responsibility for the child. Then we went on to ask about sole responsibility vis-a-vis legal custody or control. Now, what we said was that the Home Office caseworkers will look at the child's circumstances as a whole to determine who is actually responsible for their upbringing, so controlling, setting, and providing the day-to-day direction and care for the child's welfare. So obviously you need to prove all these things, and it's not a tick box matter, it's a matter of evidence. I keep saying that evidence is the name of the game. So TD case, that TD Yemen's case, we picked up from paragraph 297 IE of the sole responsibility, and then lawyer explained that. So let me come and ask you, or put a scenario before you, and let's see if we can apply our knowledge of that into the situation. Kwame wants to bring her child to the UK to join her. Akuya is on a year skilled worker visa. She says that her child now lives with her mother, that's grandmother, since she left Ghana. Look at the scenario again and critically. Once the lady wants to bring her child to the UK to join her, she is on a year skilled worker visa. Now she's saying that her child now lives with her mother, that is the child's grandmother, since she left Ghana. Okay? What are some of the pieces of evidence Akuya must provide to make a successful application? I've got three here. Let's see if we can pick them up and see which one will be the correct answer. One, show that she has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. Could it be two, obtain a letter from the child's father to confirm that she takes decisions, in the child's life? And three, she must provide evidence that the child is desirous to join her in the UK. Think about these things. I'll read the scenario again. Someone wants to bring her child to the UK to join her. She's on a skilled worker visa. She says that the child now lives with her mother, that is the child's grandmother, since she left Ghana. What pieces of evidence does she have to provide to make a successful application? Is it one, she must show that she has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life? Is it two, that Akuya has to obtain a letter from the child's father to confirm that he takes decisions in the child's life? Or three, Akuya must provide evidence that the child is desirous to join her in the UK. The clock ticks, and we'll come back after the break to take your answers. Keep going on, we'll be right back. Yes. I am now ready to pick up your answers. I know you have put them in the comment section below. You probably may have texted to our text number 0739920848, or let's see. Okay. Nora Williams says number one, Grandma show that she has full control and direction of the child's upbringing, including making all important decisions in the life. Jennifer also thinks same is number one. Let's see who else has brought in anything. Could it be two? Obtain a letter from the child's father to confirm that she takes decisions in the child's life. Benjamin Boateng both says it's number one. Show that she has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. Let's see who else. Isaac Norte says number one. Number one seems to be very popular, I guess. Keep it coming through. Keep it coming through. Let's see. Jemima Teria says number one. Thank you, Jimmy. Eric Osei says number three. She must provide evidence that the child is desirous to join her. Eric says number three. Aziz Yaya says number one, she has showed that evidence. Julian Annan says number one. Let's keep it going. Julie, thank you. Next. Benis Frimpong. Benis says number one, yes, that she has continuing control and direction. Samuel Mensah thinks it's number three. She must provide evidence that the child is desirous to join her. Letitia Abe, number one. Yes, thank you. Your contribution so massive. You've been following that. God bless. Nothing less, no stress. Tilly Duma, says number one. Kuyama show that she has continuing control and direction of the child's upbringing, including making all the important decisions. Ezekiel Johnson says number one. Well, Ezekiel, I see that you have sent in a question. What I'll do is I'll defer that and tackle that next week when we come on the program. I think we're running out of time. Well, with us, let's quickly go over to Lawyer Aswa to help us unravel this. Somebody will say it's pretty straightforward because most people, 95% of people who have answered, say that is number one, that she should show that she has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. Lawyer Asma, are we right? Lawyer is on mute.
Yeah, can you hear me?
Yeah, we can hear you now.
Yes. So so some kept them coming in, and others I'm sure are still considering which option. So let's start from the bottom. Number three says she must provide evidence that the child wants to go to travel abroad. Literally, the child is fed up with their country and want to go abroad. No, it's not by emotions of the child. So that's out.
Okay.
The next one says that get a letter from the child father to say that, hey, I want my child to travel abroad. Let her go or let him go. No, it's not the child father. Once the father steps in, that means the father is there, shared responsibility, and that defeats the principle of sole responsibility. So point two is a defeatist approach. Don't try it. Point one, evidence that you continue to have control and direction of the child's upbringing. And that is what you need, number one.
So obviously, as number one, Kuya Mansa must show that she has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. So, as Lawyer said, listen, number two is self-defeating, so don't try it. The parent must demonstrate that they are the primary decision maker in the child's life. This may include who is responsible for deciding what faith the child is raised in, how they practice this faith, where the child lives, what recreational activities the child is involved in, whether the child undergoes certain medical procedures, how the child's health is generally looked after, where and with whom the child goes on holiday, and all the things that are major things in the life of that young person. You, who is claiming to have sole responsibility, should be making those decisions and not a shared one. As people may go and say, oh, well, can the father sign this letter for me? Don't do it, because that wouldn't show so responsibility. Thank you very much, lawyer. And thank you for all those who chose number one, because that is the correct answer. Well, with that, we come into the point where we draw the curtains down. And as my tradition has been on this program, I want lawyer to just give us a quick recap of what we have discussed today. We looked at what to do when your visa application is refused without the right of appeal. Lawyer.
Yes, so today we looked at what to do if you are refused a visa and you have no right of appeal. We said that because that visa application decision was made by caseworker who works for the government, it's a public body decision. And so you can have right for judicial review. What it means is that you have to act within 90 days of the decision. You first have to let them know that you want to pursue judicial review. And once that the response comes, you move to the next stage of completing the judicial review papers. If the decision hasn't come and your 90 days is up, before it's up, make sure you start the process. And if the decision comes to say that no, they are where they are, they haven't changed their mind, then your 90 days start from that point. You pay a fee, you lodge online. We have what we call e-filing process to upper tribunal. You go through the process and make sure that you tick all the boxes and wait for a decision from the court. Once your application is granted, you apply to pursue the judicial review. Now, what it is that there will be fees involved, so you have to pay all the fees. If you don't want to pay fee, you can get what we call legal aid, but legal aid may not be available everywhere all the time, so you have to check. If you win the case, you get all your fees, legal fees, paid for by the Home Office. If you lose the case, you must pay Home Office all its legal fees, regardless of how much they have spent. So make sure before you pursue this, you have sought advice and you know that you have high chance of pursuing the claim. This is what we brought to you today. Have a wonderful weekend.
Yes, lawyer, thank you very much. And we wish you a wonderful weekend as well. I know sometimes it becomes quite short, but once we started February, on a weekend like this, I'm praying that things will go so very well for all of us. BWF Solicitors would want to wish you the very best in the month of February, the month of love. And when it is that you would need support, guidance, every bit of it through your legal journey, speak to BWF Solicitors on 0208 493 7340. The Ghana number is 00233 55589 In emergency situations, call the emergency number 004477 1276 1884. And also, if you would want to contact lawyer Charles Asma directly, please remember his number is 07947 636037. 07947 636037. Well, I want to say thank you very much to Lawyer Charles Asma for your time this afternoon, and to all the BWF Solicitors family, from the principal right down to the very last person, that is me, and to my technical crew for BWTV, talking about my producer, Professor Ade, for his tolerance, time, and everything, to Shilankra and Padmo Dodu for the aesthetics and the admin work, and to the researchers and, of course, contributors to the program. I want to say thank you very much to all of you. And to you out there who patronize the program, I want you to come back again, because same time next week, we'll be having another edition of this very wonderful program, The Community and the Law, and that will be brought to you again by BWF Solicitors. Until then, my name is Oreku Frimpong. Good evening.